first case on the call of the docket this morning is agenda number 9, and the matter is 126153 Thomas Brown versus the Illinois State Police. Mr. James Angel, you may proceed.
May it please the court, counsel. This case presents a basic issue of whether misdemeanants such as Thomas Brown, who didn't serve a day in jail post-conviction and have been determined not to be a danger to themselves or others, should have their day in court and get an up or down vote on whether they are sufficiently trustworthy to possess a gun. And it takes the form of two legal issues. The first is under the Floyd Act, whether Mr. Brown has had civil rights restored by virtue of California automatically allowing misdemeanants to repossess weapons within after 10 years from the date of their conviction. The second question, assuming the answer to that is no, is whether Mr. Brown may bring an as-applied challenge under the Second Amendment, saying that even though laws banning misdemeanor domestic violence are generally valid, whether in a particular case it would be unconstitutional as applied to him. A little procedural history on this. Mr. Brown was convicted in California right after 9/11 of corporal injury to a spouse. He according to this testimony, he basically, given the circumstances and his employer just wanted him to get this done, he took a plea, no order of protection was entered. He was basically sentenced to time served, 3 years probation. And his understanding is this didn't affect his firearms rights. Fast forward to 2016, he goes to purchase a weapon, and that triggers a background check, which pulls up the California conviction. He's denied on the purchase, and then he's has his FOID card revoked. After he was revoked, he filed a petition with the Putnam County Circuit Court, which raised the two issues. The first issue was the FOID card, which was raised for purposes of preserving the issue, because since after quorum, almost all appellate courts read that decision as that circuit courts could not grant FOID rights as being consistent with federal law post the 2013 amendments. Then there's a second issue, and he brought the second issue, which is the as-applied challenge. We went to a hearing in 2018. Mr. Brown made clear that he was bringing a Second Amendment challenge. The Attorney General categorized as a substantial justice hearing. The Circuit Court, after a hearing and briefing, granted Mr. Brown a FOID for two written reasons. One, the facts of such, based on his prior wife's letter, there are some real doubts as to whether he actually committed a crime. And second, his current wife has guns in the house, and that indicates a lack of danger. The state took an appeal. It went to the 3rd District, which actually had oral argument in 2019. 1 month later, the court stayed their decision pending resolution of this court's decision in Johnson. Johnson came down in January 2020, but 3 months later, the 3rd District, by a 2-to-1 vote, reversed the Circuit Court's decision, saying Mr. Brown has not shown restoration, and his Second Amendment challenge is premature because he needs to seek a pardon. In dissent, Justice Holdridge said, addressed the first issue, saying that under California statute 29805, I believe it was formerly 12021, that California had given him the dispensation of forgiveness contemplated by the statute, and therefore he had been restored. The Third District also did not discuss their prior opinion in Pornaris, which has been cited in the briefs, that Pornaris was a case where a gentleman had a felony conviction for burglary and applied for a FOID. He was denied at the trial court. The Third District said that once he finished his probation, he retained the rights to serve on a jury and hold public office, so therefore he had been restored. That opinion wasn't discussed in the appellate court below. The only difference between Pornaris did distinguish a prior case called People versus Heitman, where the Third District said gun rights are not civil rights restored, but that decision does not survive this court's opinion in Johnson. So,
what's the counsel? But California, the decisions of that court are different. They don't consider the gun rights as a civil right. Is that correct?
Well, my belief is California federal courts have said that, but in Johnson, this court rejected cases. I believe one was called Chauvin. This was Johnson, paragraph 36. I believe that all the cases that just take the Logan three rights view are largely pre-Heller. Chauvin relied on I believe 2005 case, which is pre-Heller. And this court said that regardless of what other states say, gun rights are civil rights restored. Johnson also distinguished Enos versus Holder, I believe it was paragraph 48, where they said that Enos was different because that was automatic restoration, but more importantly, that this court said Enos is not a well-reasoned opinion. And the view that whether California recognizes FOID rights as, whether a California federal court recognizes gun rights as civil rights restored really has no bearing, because as this court has said, we can decide federal law as well as any other court other than the Supreme Court. And also, under Karen, that's where the court said that, okay, the state of the convicting state decides restoration, but we decide what this means. That was where they had the use clause, and that Karen was one where Massachusetts gave some rights. I believe it was Massachusetts gave some rights back, but not others. And the Supreme Court said under federal law that isn't sufficient because the federal law decides that, and the whole point of the federal law is we want you states to decide whether people who are seeking their gun rights back are trustworthy. In this case, the first issue is controlled by 65C4, where we have the issues which has been argued before this court multiple times. The first issue, no felonies within 20 years. The first three elements are, I think, are largely undisputed. There may be an argument that the state has made, Attorney General has made, that Mr. Brown's dangerous, but post this court's recent decision in Evans, where this court said abuse of discretion, that goes more towards supporting the trial court's decision here that Mr. Brown is not dangerous or likely to act contrary to public interest to the circuit court's satisfaction. So really what we're arguing over here is probably just the fourth element of 6510, which is C4, which is contrary to federal law. Basically under 922G9, a person's not allowed to possess a weapon if they have a misdemeanor conviction of domestic violence, but 921A33 defines that, and I believe paragraph 2 says it's not a disqualification if civil rights have been restored.
Mr. Angel, if we don't agree with you, does that mean that it's left with pretty much a perpetual ban for misdemeanors?
That would be the second issue. I mean, the court's decisions, such as Johnson and Quorum, make clear that if we can grant Mr. Brown relief under the Floyd Act, that's the first step. But if not, then we address the constitutional issue. So then you would be addressing the perpetual ban that you raised in Quorum in a footnote as to whether the state may require a pardon and may perpetually ban individuals who are not a danger to themselves or others. So my argument here is that, first argument is that this is civil rights restored, which breaks down into two issues. The first is civil rights, which addresses Justice Overstreet's question. And then the second issue is restoration. And the easier issue is probably the restoration. Johnson and Quorum both tell us that the issue for restoration is, quote, dispensation of forgiveness, unquote. And Johnson also, of course, tells us that firearm rights are civil rights for purposes of federal law. In terms of the restoration reason, I think the easier issue is first to say that this wasn't restoration means the Pornaris decision was wrong, which cited Article 13, Section 1 of the Illinois Constitution and 730 ILCS 5/5-5, which basically says that upon release from probation, that an individual is restored, like a felon like Mr. Pornaris is restored. Also with Caron, that court said that early on in the opinion, said that automatic restoration is restoration. And that makes sense because automatic restoration oftentimes are people where we're not going to have an individual hearing. Your crimes are so minor that if you don't have any further infractions in the next 10 years, that we're going to deem you trustworthy. And also California Penal Code 29805 was the restoration provision, which had automatic restoration provision, but there's also a provision 29855, which is for if you're a law enforcement applicant within the 10 years, you can apply and show that you're not dangerous and get your guns back. So it would be awkward to say that 29805 isn't restoration, but 29855 is restoration. And then that also tails to the issue of civil rights. Clearly, California's restoration under 29855, where we're giving you a gun because you're going to be a law enforcement officer, is restoration. It would make illogical sense to say that that's not restoration for purposes of federal law. Then also, with respect to the civil rights, to say that that's not to defer to California would just create a whole bunch of anomalies. First, you'd have minimal offenders such as Mr. Brown, who are ineligible. You'd have moderate offenders such as Mr. Pornaris, who are eligible and get their firearms back. Then you have your most severe offenders who are actually hypothetically eligible, but as a practical matter, no responsible judge is going to give them a gun. So that's the first anomaly, is that it creates absurd results, which is what this court in Johnson and Quorum tried to prevent. Also in Quorum, that the court noted in paragraph 18 that if Mr. Quorum had spent 1 day in jail post-conviction, he'd get his firearm rights back. I believe the same situation applies here, whereas Mr. Brown had spent 1 day in jail, California jail, post-conviction, he'd be getting his firearms back. And then also, it raised another absurd result is the question of whether Mr. Brown can actually possess a gun in California. The Attorney General has given conflicting positions in the record. 120 suggests C-120 suggests he can, although it's ambiguous. So either the answer is yes, he can possess a gun in California, but he can't possess a gun here, or no, he can't possess a gun in California, which basically means that 29805 is illusory. It's a deceptive statute that California is essentially saying we're going to promise to give you your FOID rights back after 10 years for misdemeanor, knowing that the federal government is going to ban you. I don't believe governments can act like that. Also, the question is regarding California state sovereignty, and the simple that we have to defer to California's position on what's a civil right. But the simple answer there is California has enacted this statute. It has deemed Mr. Brown not a danger. If California believes this is a wrong judgment, California can pass a statute tomorrow, either amending the statute or just saying that you're permanently barred. But until then, California has decided, the convicting jurisdiction has decided that people like Mr. Brown are not dangerous. Also, for just to rely on California, or not even California state courts, a California federal opinion discounts this court's reasons given in Johnson why paragraphs 42, 43, why civil rights, why restoration of gun rights or civil rights restored, where this court said it would be odd if we use these other rights as proxy to determine trustworthiness, but then we don't but then we don't consider the very right being restored as under the FOID statute as an indication of trustworthiness. It also disregards this court's recent opinion Reed that people plead guilty for all various reasons, and therefore there may be situations where somebody just pled to make this go away. So for those reasons,
May I ask you a question before your red light goes on? Of course, Section 10 of our statute provides a series of requirements, and we've been focusing on obviously the more difficult one, the legal issue here about civil rights restored. But there are other factors that are required to be determined in a Section 10 hearing. If we were to agree with you, should we remand this case back to the circuit court to develop a record as we did in the Evans case?
No, Your Honor, because Evans was one where they did not have a full evidentiary hearing. Here we had a hearing, we had transcripts, all evidence was before the court, whether it was under the Second Amendment or as the Attorney General categorized as the
Do we have a written opinion so that we could review the reasoning of the trial court?
The trial court did enter a brief opinion after briefing, which said, one, there's already guns in the house, so that the implication is that where there's guns, because Mr. Brown's current wife owns a FOID card, and he hasn't done anything dangerous with them, so that implies he's not dangerous. But also the court said that I have severe doubts that he actually even committed a crime. There's also a transcript, so the court heard all relevant evidence. It was a contested hearing. All finding, to the extent there's doubts in the record, all findings should be construed in Mr. Brown's favor. And then the second issue, briefly, is assuming Mr. Brown loses that, is whether whether he has a Second Amendment right to pursue, whether it can bring a Second Amendment as applied challenge. And that has broken down into two questions. The first is whether he's required to seek a pardon. And the general rule in Patsy and cases since then is that we don't require you to seek a pardon for constitutional rights, where it's just judicial or administrative proceedings. And those at least have safeguards. Whereas a pardon, it's just whether I feel like granting it today or not. And then it's contrary to this court's opinion in Evans, where that basically we want to give the applicants their day in court. Also, the decisions that found that were cited, such as Stemmel, Harley, and so forth, all those courts actually, and some which said there was no Second Amendment challenge.
Your time.
Thank you.
Ms. Buell?
Good morning, Your Honors, and may it please the Court. Assistant Attorney General Caitlin Buell on behalf of Respondents Appellees. In this case, Brown lied on his FOID card application by omitting from that application a misdemeanor crime of domestic violence, or MCDV, conviction that he received in the state of California in 2001 for inflicting corporal injury on a spouse. Because of this lie of omission, Brown received a FOID card in Illinois until 2016, when he attempted to purchase a firearm and failed a federal background check. ISP then revoked Brown's FOID card because of this MCDV conviction, and Brown petitioned the Circuit Court for relief. The Circuit Court granted Brown relief, and in doing so ignored ISP's testimony concerning the necessity for truthfulness on a FOID card application. The appellate court reversed based on this court's statements in Johnson concerning Illinois' unique procedure for restoring civil rights, including firearm rights, for Illinois misdemeanor crime of domestic violence convictions. The court noted that this restoration procedure was not available in California, and that Brown would be required to apply to California in order to gain restoration of his firearm rights before attempting to obtain a FOID card in Illinois. Brown would now ask this court to grant him a FOID card by applying Illinois law, ignoring California law, and ignoring ISP's testimony concerning the necessity of honesty in FOID card applications. This court should reject Brown's arguments for 3 reasons. First, in Johnson, this court held that the law of the convicting jurisdiction controls whether a person's MCDV conviction qualifies as a disqualifying one for firearm possession under federal law. This includes the question of whether one's civil rights have been restored by the convicting jurisdiction. And here, the convicting jurisdiction of California employs a different restoration process for civil rights, including firearm rights, than in Illinois. And California would not grant Brown this relief without him first seeking a pardon, which he has not done. Second, Brown is not entitled to relief because the Circuit Court's findings that he satisfied Sections 10C2 and 10C3 of the FOID Act were against the manifest weight of the evidence. As the Circuit Court ignored ISP's evidence concerning the severity and break in public trust that occurs when an individual lies on a FOID card application.
Counsel, I mean, didn't Evans change that, though? The manifest weight, it's an abuse of discretion on C2 and C3.
It was my understanding that for the manifest weight for a 10C2 and 10C3, that was in a circumstance where there hadn't been an evidentiary hearing, rather just the documentary evidence. But even under an abuse of discretion standard, the same is true, that the Circuit Court completely ignored ISP's evidence concerning the necessity of truthfulness on a FOID card application. The last thing I would like to discuss today is Brown's as-applied constitutional challenge being premature because he has not sought a pardon in California, and because he's one of the individuals that Congress has categorically excluded from firearm possession under Section 922 because of the serious nature and correlation between domestic violence incidents and firearms. To begin, Brown is unable to obtain relief under Johnson until he can once again possess firearms in the state of California. In Johnson, this court recognized that the convicting jurisdiction controls whether a conviction qualifies as a misdemeanor crime of domestic violence under federal law.
Counsel?
Yes.
The opposing counsel indicated that his belief was he could get a gun in California based on this automatic restoration after 10 years.
That is incorrect, Your Honor. The California statute 28905, which was previously California Penal Code 1203, is not a substitute for an affirmative statement of restoration and forgiveness that this court noted was so important in Johnson. The California statute that allows misdemeanants to possess a firearm 10 years after conviction is a matter of state law forbearance, not forgiveness. It allows them not to be prosecuted as a matter of prosecutorial discretion, but it does not give that level of forgiveness that this court noted was so important in our state's FOID Act. Illinois, on the other hand, dispenses such forgiveness after an individualized hearing in which individuals are taking a look at whether one is likely to act in a manner dangerous to public safety or whether granting them relief would not be contrary to the public interest. California doesn't have this sort of individual hearing procedure. Instead, it decides to restore rights through the pardon process. As was noted on pages 29 and 30 of my appellee's brief, there's the Board of Parole Hearings in California. It considers pardon applications, and as part of that process, it considers an individual's self-development, the use of rehabilitation programs, the age of the conviction at issue, and any other extraordinary circumstances that justify restoration of the firearm right.
So counsel, it's illegal for Brown to possess a firearm in California, but it's also illegal for the prosecutor to prosecute him for possessing a gun in California.
The California law is ultimately the California law would allow a prosecutor to prosecute someone within 10 years.
Within 10 years.
After the 10 years. It does appear from my reading of the statute that the prosecutor likely could not exercise their prosecutorial discretion to do so. However, an important notation is that California is not using the same restoration of rights analysis as this court adopted in Johnson. And it would ultimately be inappropriate for a state court interpreting federal law to reject a three-courts analysis when the state of California itself has not done so. Instead, all we have is the affirmative statement from California that the Board of Parole Hearings through the pardon process is going to grant that dispensation of forgiveness that this court found to be so important in our own FOID Act itself.
So if we assume that that's forgiveness, that 10-year law in California is forgiveness, if we go on that assumption, the issue here really is whether we have to defer to California's judgment on whether or not gun rights are civil rights, correct?
Correct. And the state of California simply does not use the same civil rights formulation as this court does. We can note that based on federal courts that are sitting within the jurisdiction at issue here, and the courts in both Chauvin in the Ninth Circuit and Enos, which I know that this court found was not persuasive in Johnson. However, they were taking a look at the inflicting corporal injury on a spouse misdemeanor crime of domestic violence conviction, the exact same one that Brown has here. And they found that because California did not revoke the rights to vote, hold public office, or serve on a jury, that restoration was not appropriate. And instead, the Ninth Circuit has also noted in the case of Fisher that the pardon procedure is still available to him. And it's that pardon procedure that California really focuses on in order to restore civil rights. In addition, there are different anomalies, as Mr. Brown's counsel has pointed out, or disparities between the way Illinois law is acting and California law is acting here. But the United States Supreme Court stated in both Logan and in Beecham that these sorts of disparities are common because of the way Congress has set up Section 922G9. By Brown's solution too creates disparities. It would mean that someone in the state of California who has the same conviction for a misdemeanor crime of domestic violence for inflicting corporal injury on a spouse would not be allowed to possess firearms, but an individual in Illinois who has that same California conviction would be able to. Only the state that is doing the condemning can do the forgiving. And so, by honoring principles of judicial comity, we ensure that the state court does not infringe upon what California courts have not expressly done. In addition, Brown is not entitled to relief because the circuit court's findings that he satisfied Section 10C2 and 10C3 of the Floyd Act under any standard of review resulted in the circuit court ignoring these factors and ISP's testimony concerning truthfulness on Floyd card applications in granting Brown relief. Illinois State Police Assistant Bureau Chief of the Firearm Services Bureau, Jennifer Radzovic, testified that Brown should have answered yes to the question of whether he had a misdemeanor crime of domestic violence on his application. This is important to require you to be honest in your application, as it prevents perjury in the criminal history process, and providing false information on a FOID application is alone a basis for denying an application or revoking a FOID card in the first place. And here, Brown's misrepresentation led him actually to be possessing a firearm when he was not entitled to one. Instead, he knew his offense for inflicting corporal injury on a spouse was indeed a domestic battery, as he characterized it himself during his Section 10 proceedings, and his lie of omission simply downplayed his responsibility in this instance. He didn't accept responsibility for this offense by openly noting it on his application, nor does he accept responsibility for the plea of guilty now, as he continues to contest the facts, the severity, and downplay it even before this court. The public is entitled to know that those who are possessing their FOID cards are trustworthy to do so, and entitled to have all individuals who possess FOID cards go through the proper process and complete all state requirements, including to be honest. Third, Brown's as-applied challenge here is actually premature because he has not attempted to obtain a pardon in the state of California for his misdemeanor crime of domestic violence offense. Brown can still apply for a pardon in the state of California. He admitted on pages 23 and 24 of the record that he has never tried to do so. And as Justice Tyson Garmon noted in quorum, something cannot be futile without ever having been tried. A remedy isn't unavailable simply because it is discretionary or it might resort to fail, and the constitutional challenge here should be addressed only as a last resort. The federal courts, too, have found this to be a worthwhile argument, as noted in Fisher, when the Ninth Circuit rejected an as-applied constitutional challenge for an individual seeking firearms from the state of Hawaii, where the state of Hawaii's only restoration mechanism was also a pardon. The pardon process encompasses that forgiveness from the state of California, and the parole board, again, will do a holistic evaluation of the individual, similar to what our FOID Act does. Brown has not availed himself of this process and should be required to do so before seeking his Second Amendment challenge in these Section 10 proceedings. Brown also would like this court to decide the constitutionality of Section 922, as no federal court has. Brown argues he's entitled to as-applied relief under the Second Amendment because a long time has passed since his conviction, and he's a law-abiding member of society now. But these sorts of arguments are inappropriate for courts to consider, as explained by the Ninth, Sixth, and Fourth Circuits in Chauvin, Stimmel, and Harley. If this court has no further questions as to the constitutionality or other issues in this case, we would rest on our briefs and ask that you affirm the appellate court's judgment. Thank you.
Thank you, Ms. Buell. Mr. Angel?
With respect to the Attorney General's argument that Brown lied on his application, if Mr. Brown really understood what was going on, he would have served 1 day in jail in California post-conviction. All the evidence in the record suggests, like the Johnson petitioner who believed that the conviction in her case did not affect her firearms, Mr. Brown did not understand that, and unfortunately that's all too common in this context. And as Justice Burke pointed out, this is basically an abuse of discretion standard as per the statute. So the question did the circuit court abuse its discretion in saying that it was satisfied Mr. Brown was not a danger? The circuit court heard the argument regarding Mr. Brown's alleged untruthfulness. He rejected it. He also had Suzette Brown's letter regarding not only the incident, but whether she believed Mr. Brown to be a danger. And also, with respect to the law of the convicting jurisdiction, the Attorney General attempts to mischaracterize this as, okay, Mr. Brown can't be prosecuted, but, well, he can't be prosecuted. He can't be fined. He can't be stopped for possessing a weapon in California. So that begs the question of, what does Section 29805 actually do? If you can't be arrested, you can't be stopped by the police, that's a restoration. Also, that argument that this isn't a restoration has to totally ignore what 29855 does, where it restores in certain circumstances under 10 years. The Attorney General suggests that we should have an affirmative restoration, but that's clearly not the law after the U.S. Supreme Court decision in Karam, where they said automatic restoration counts, and especially where it's minor offenders. And here the Attorney General is simply seeking to ask this court to substitute its judgment for the trial circuit court, which was in a better position to see this. With respect to her argument that Mr. Brown has to seek a pardon, there's two major problems with that argument besides the ones I've already addressed, such as the Patsy case. The pardon argument has been misconstrued. What Coram and Johnson said is, if we can uphold the judgment based on a statutory basis, we don't reach the constitutional question. It didn't say that we can impose endless burdens, such as a pardon where there's no time limit, to deny a applicant their day in court. And the Attorney General says as long as a remedy is available, that should be pursued. Well, if a pardon's denied, to the best of my knowledge, you can always apply again. So hypothetically, that remedy is never met. In terms of the as-applied challenge, the Attorney General says Mr. Brown can be category excluded because of the harm that domestic violence causes. Domestic violence definitely causes major harm. Congress has an important objective in banning that, but Congress itself did not believe that a perpetual ban was necessary, as it created the proceedings under 21A33 in Section 6510, where parties can petition and show that they're not former relief and that they are trustworthy to possess guns. The whole point of that section, but the Attorney General argues that if you have no civil rights restored, you shouldn't be able to have a Second Amendment challenge. But the whole purpose of the statute is Congress is saying to the states, hey, we are deferring to you to determine whether these applicants are trustworthy. It wasn't ever meant to just categorically exclude offenders who didn't lose any civil rights from ever being able to possess a firearm. So that for that reason, in those circumstances where at least an applicant has not lost any rights and hasn't spent any time in jail post-conviction, those are the cases where a Second Amendment challenge is most appropriate. This court's suggested in quorum that, the trial court in quorum found unconstitutional as applied, as did Johnson. This court's opinion in quorum suggested that a perpetual ban would raise serious constitutional issues, and that issue is here before today. Justice Burke in her concurrence raised the question, she didn't answer it, but whether a state could impose basically an indefinite pardon requirement, and also more importantly, can we perpetually ban individuals who are not a danger to themselves or others. And we would respectfully submit the answer is no, particularly where Congress itself did not believe a perpetual ban was necessary. So recognizing a Second Amendment challenge in these circumstances where the evidence is going to be very similar to a Section 10 hearing actually furthers Congress's objectives. And so for those reasons, we would ask this court to find that Mr. Brown was restored by operational law of California, and that the California statute does what it says it does. If California has a problem with Mr. Brown being able to possess a firearm, California can change its very clear statute. Alternatively, we'd ask this court to reach his Second Amendment issue and say that in this case, a perpetual ban on his right to possess firearms violates his Second Amendment as applied.
Thank you, Mr. Angel.
Thank you.
Case number 126153, Thomas Brown versus the Illinois State Police, was taken under advisement as agenda number 9. Thank you, Ms. Buell and Mr. Angel, for your arguments this morning.